If we had to have proof beyond a reasonable doubt for a child custody case, you wouldn't be able to get a verdict.
There'd be no custody.
Because I don't know. Like, you seem like a prick, but you're the parents.
I mean, besides opening and closing, you're never speaking directly to the jury. You're just asking questions from witnesses or from the accused it's telling the story through that.
Because you're talking to the jury during jury selection. Yeah. It's the only time you get to have that give and take. Mm-hmm. But you want to mimic that process in your closing argument in the sense that you want to be asking questions that they're going to be asking in their own heads, and then you answer them. I mean, can you imagine being a juror and someone say something different than what you heard in the evidence, and you have to sit there and shut the F up? I mean, that's such an awkward system.
You know, at the end of the day, if the DA gets a not guilty verdict, they're like, oh, shucks, and they can go and, have a steak dinner with their wife or husband or whoever. If one of our clients is innocent and they're convicted, they go to prison, potentially for a long, long time, and their life is totally ruined.
The process that we have is of great value, and the way we think about cases can be trained to others. That's why I've historically always had associate attorneys and other attorneys working cases with me. There's a few reasons for that. Reason number one, I heartily believe that two heads are better than one. Mm-hmm. Why are two heads better than one? Well, you can scale the work, you can do more work, get more results quickly, and if time is finite, you can get more work done. And if time is not finite and you have lots of time to do it, or regardless of the timeline, there's synergies involved in the sense that, yes, there's make work, two different people reviewing the same materials, but that little time and effort it takes to become aware of the facts of a case, put into a human mind that's familiar with the strategies and the processes that we have at this firm.
And that has their own individual experiences and ideas and the like. I mean,
yeah, it's not a machine running on itself. It's an augmented reality machine that we have this framework, this process within our minds that's overlaying an existing system of governance that we have based upon our training and experience and personal life experiences, right? Like, just like you pick a jury, you don't want tabula rasa, you don't want some blank slate, you want someone with common sense and reason that comes from life experience. That's the interesting thing about jury trials in general. Is it improvisational jazz, or am I playing a set piece? Well, I kind of want it to be a communication process, right? I want to be talking with them in my closing argument. I don't want necessarily to be talking at them. They can't talk back, but they are speaking internally. They're having an internal dialogue. I'll say something, then they'll think of something that they would say in response. I mean, can you imagine being a juror and someone say something different than what you heard in the evidence, and you have to sit there and shut the F up? I mean, that's such an awkward system.
And you don't even get to ask any questions yourself. And for the most part, I mean, that's something that really kind of blew my mind, just learning about the law and how it works. I mean, besides opening and closing, you're never speaking directly to the jury. You're just asking questions from witnesses or from the accused, it's telling the story through that.
Because you're talking to the jury during jury selection. Yeah. It's the only time you get to have that give and take. But you want to mimic that process in your closing argument in the sense that you want to be asking questions that they're going to be asking in their own heads, and then you answer them. So you're trying to anticipate the way they're thinking, just like layering memes and giving more and more information. We're layering a meme environment too, right? Because you plant like this seed. You're seeking the truth. You're trying to find out what they're thinking and why they think, but you're also trying to program their minds to think a certain way about how they process information coming from the government in a criminal case, and you're saying words and phrases to plant ideas so they'll filter information a certain way, right? Kind of doing some pro-liberty propaganda as a defense lawyer. You're trying to tell a story in a way they don't know that they're being told a story where they're the main character, right? They think they're going to be getting told a story about some dude that's been accused of a crime. Yes, but that story, any good story is going to be the hero's journey, right? They're going to have a similar structure. You're going to have their ordinary world. Oh, look, who's the hero in this story? It's the poor, falsely accused client, right? That's what you'd think if you're writing a script up for a trial, that you're trying to tell this disjointed story where you don't have conversations. You have each character telling a story in an examination, and then the next character tells a story. So really, they're telling the story is presented in a courtroom setting, but it's told in a way that's not familiar to people. Mm-hmm. I mean, they've seen it on TV, but
I feel like there's a lot more monologuing on TV. I think that's where, and both my parents were lawyers, and for a little bit, and practiced law for a little bit before actually doing other things. But I feel like I was shocked when I learned that it's just direct examination and cross-examination, because really, I mean, if I didn't know any better, I would think, well, all the lawyer has to do is ask questions. Ask, oh, what did you see here? What did you see there? And so that's something that's really mind-blowing to me, because on TV, I feel like, the hero, and of course, oftentimes in a legal TV show, the lawyer is the hero. And if they're not the hero, then they get almost no time. But, in a TV show, like Law and Order, where, there's always a DA, and that DA, usually it's them giving their opening or their closing, or, like speaking passionately about why, in that case, why they think the person is guilty. It was crazy to me. I mean, it's hard to imagine, how would you tell a story if you weren't allowed to say anything and you just have to ask questions and get other people to tell it for you? I mean, it's an incredible art.
Yeah, I mean, it's interesting in the sense that you think you're trying to tell a story passionately, like you see on Law and Order, where you can ask these very not even leading questions, but the sort of questions that they ask in the TV shows that are just somebody looking cool and playing gotcha. Like, you can play gotcha, and you should play gotcha in cross-examination, but you don't get to turn to the jury and talk to them like they do in TV.
Yeah.
So that's a plot device that they use in those shows to move the story along, because jury trials can be very boring when the lawyer doesn't get to break in and sort of break the fourth wall and talk to the jury in the middle of the case. So you have to find legal ways to do that. The best way to do it is you can do little mini closing arguments in the middle of trial. When there's an objection to a question and they say objection relevance, anytime someone does that, I'm like, oh, thank you very much. Mm-hmm. Counsel, well, let me tell you why it's relevant. And I get to frame that evidence, right? That you're hearing this evidence right now, ladies and gentlemen of the jury. And I'm using it to prove this fact that's super crucial for my case. And if it works, and obviously it's going to, I wouldn't be asking the question, then you will rule in my favor. Which is why it's relevant. It's logically relevant, because it makes a fact of consequence more likely that can prove or disprove a case. And so that's an opportunity to break the fourth wall. And then
they're almost queuing you up. All of a sudden they're kind of asking you the question, you're getting to answer finally.
Yeah, I mean, and that's great. Well, if the DA doesn't understand why I'm asking a question, then probably a juror doesn't get why I'm asking this question. Of course, I will, in my closing argument, painstakingly make all the inferences for them, because they may not know what I'm doing and why I'm doing it, because maybe I didn't allude to it in my opening statement, because I wanted to be surprising. I didn't want the DA to know, so they would maybe not do something. It's very, very, you have to be very strategic at trial. Like, you give the information that you need to, but you don't want to give too much so they can anticipate the direction you're going by virtue of a question you're asked, and prep the witness for that question, and then you don't get the element of surprise, and they can be prepared to do their little lie or little workaround. Because at the end of the day, the only good stories that are worth telling are ones that are true. Our particular practice, we have the luxury of vetting people that are falsely accused and take the cases that we really enjoy. Yeah. But regardless of the case, if you're going through a trial, yeah, you've got to work the art of telling the story so it follows the rules of the case, the rules of the courtroom. I would contend that the hero's journey that we're telling is not that of the attorney, it's not that of the client, it's that of the juror. And so I'm not just telling them a hero's journey story, I'm giving them the pieces of the story that they can in turn make their own, so when they do what I ask them to do, they go home and proudly tell their spouse or their kids or their loved ones, oh, hey, what did you do today? How was your jury trial? Oh, let me tell you, we saved this man who was falsely accused from this grievous miscarriage of justice. Or we protect this victim that was harmed by somebody, right? You want to create a verdict for them that makes them feel good to do it, so that they want to go share it with others. Because no one's going to do something that violates their conscience, right? Mm-hmm. Oh, technically the weight of the evidence wasn't sufficient to prove the case. We feel real shitty about it. No, you want them to be like, motherfucker, like we protected the next guy who's falsely accused by letting this piece of shit off because he's not the hero, right? I'm the hero for protecting the justice system as a juror to make sure that these shitty cases don't get through. Even though he's probably guilty, probably did it, but they didn't prove their case beyond a reasonable doubt. That's the foundation of not just the criminal justice system, but of a civilization that works without having chaos and injustices, right? Because if you can't trust that the government is being held to this burden, what's going to happen to you if you're falsely accused or your uncle or brother?
Especially when the government has pretty much unlimited resources. And even our clients, you know, it's very, very hard to keep these cases going and to get all these experts and all these witnesses. And I mean, the state can pay for that. And that's kind of something that we've talked about is that, you know, at the end of the day, if the DA gets a not guilty verdict, they're like, oh, shucks, and they can go and, you know, have a steak dinner with their wife or husband or whoever. If one of our clients is innocent and they're convicted, they go to prison, potentially for a long, long time, and their life is totally ruined.
Yeah, and even like a righteous victim, they get their day in court and there's an acquittal. I mean, it stings, but it's psychological. Like a falsely accused individual getting convicted, I mean, it's big consequences. Mm-hmm.
And also, I mean, if somebody's an accuser and if they, you know, have their day in court and if the person is found not guilty, that doesn't necessarily mean that the jury didn't believe them. It might just mean that they couldn't prove it beyond a reasonable doubt.
Yeah, the way I talk to juries about it, like sitting here right now, do you think our client is guilty, innocent, or I don't know? And, you know, I think he's guilty or I'm unsure. I was like, look, ladies and gentlemen, be honest. Like, he's sitting here where there's smoke, there's fire. Like, nobody just gets arrested or charged with a case for, like, you know, being in the wrong place at the wrong time. Maybe, but what are you doing in the wrong place? You're like, you know, like, usually people are guilty of something. They're never perfectly innocent. Like, they did something mean to cause somebody to do a false accusation. Maybe they were driving too fast under the circumstances, but not in a criminal way. Maybe they're just being negligent and not reckless.
Maybe they were a bad parent, but not an abusive parent.
Yeah, maybe
they were bad, you know, or they were disloyal to their partner. They weren't, you know, violent towards their partner, but they were disloyal. They did some, as you said.
Or maybe they were violent against their partner, but not as violent as they were falsely accused of being.
Or violent against their partner, but not violent against their children.
Yeah, yeah. So I mean, there's only like one case of like an innocent man ever that flawless in every way. So none of our clients are going to be coming to trial like lily white. If they were, don't make it through the process. Like false accusations against people that can easily disprove themselves because they live this perfect life, you know, that maybe the cops don't believe them. Like I don't see those. Doesn't say they don't happen. They just maybe get filtered a little better. But if you're acting in a way that causes someone to make a false accusation, you've probably got some like self-improvement work to do. That's all I'm saying. They have to do this like mental shift. So have you ever heard of a concept of like something unless maybe something else? Oh yeah. What is that? Innocent unless proven guilty. No, they always say innocent until proven guilty. And the jury instruction is actually innocent unless and until proven guilty. So does anybody see the difference in that? And they'll be like, oh yeah, because innocent until proven guilty sounds like
they're going to be proven guilty.
It's a foregone conclusion.
Like, yeah, at some point you're like, okay, that was the line. You know, they're proven guilty.
Yeah, innocence is a conditioned precedent to being proved guilty. Innocent
and it's interesting to me because that's something that I thought about just working on some of these cases. That's so important, and the way that you state that is so important. You know, unless and until proven guilty, and the way that you state, you know, my client right now legally is not guilty. You know, halfway through the trial, he's not guilty. The only time the jury has to assume that he or she is not guilty. I find that so important because otherwise, you know, you have a client who's sitting there, they're accused of something. The facts could show that they're not guilty, that they're truthfully not guilty, but confirmation bias is a heck of a drug, heck of a force. I mean, I actually asked my mom about, remember how you asked me when my mom was on the grand jury, and she actually told me, I know that you'd like this, that she was saying, wait, basically like, hey, pump the brakes, like let's consider whether or not there's actual evidence here. And there was somebody on the jury who was the foreperson who was like, well, they must have had a good reason. So let's go, come on, true bill. My mom says she convinced one younger woman to vote with her against indictment on some of the issues. But I mean, it's terrifying. It's one thing to have grand jury, where you have the foreperson saying, well, they must have had a good reason. Let's vote in favor. Basically saying, if you don't vote in favor of every single one of these indictments, you don't trust the police. You think that they're liars, etc. That's terrifying, and that could happen at trial too.
Yeah, and the way to inoculate that is in jury selection to say, okay, so you're driving down the road, you see a cop pulling someone over, and somebody doing this or doing the walk and turn. What do you think? Hey, that guy is doing what? He's a drunk driver, right? You never think, you know what, I'm going to reserve judgment. No, like, we're naturally inclined, and we should be judgmental of everything we see. We should always be having good judgment. We should be judging things. Like, you see something that looks like a dangerous situation, I'm not going to ask for a trial. I'm not going to be like, you know what, you're looking at me, I'm feeling something like, like when you get that look in somebody's eyes, they mean violence. Like that look a man can give that's like, all right, this is not ending well, versus, oh, wait, he was just, had indigestion or something, and he wasn't really being mean. Like, why take the risk on a dark night, right?
No, I mean, you don't say, well, okay, I have to make sure, like, I'm going to wait until I'm beyond a reasonable doubt that he's going to attack me. You go across the street, or if somebody's acting weird, you say, okay, I'm going to go now.
That's the problem with the criminal justice system. It is not in our human nature. No one has done that. So you have to not just give them these platitudes, like what does proof beyond a reasonable doubt mean? Oh, it means, I'm convinced to a moral certain. Like, no, give me a framework, give me a rubric for processing that information, and that's what I'm going to do by the way I phrase my questions to the jury. So when you get to the presumption of innocence, all right, so innocent unless and until proven guilty. You can walk through that whole process. So sitting here, why does that process even exist? Well, you let the jurors teach the other jurors. So you'll have basically a civics class. Oh, that exists because the government's really powerful, and we don't want to give away our liberties, and we got to protect the people. You get great things about liberty. People talk about the Constitution. Is there another system we could do? Like, we could presume someone's guilty unless and until they prove themselves innocent. Who thinks that would be a good idea? Somebody raises their hand. It's like, all right, ma'am. See, that's a completely valid opinion to have. There's essentially billions of people on planet Earth that live in totalitarian regimes that maybe they get a chance of doing that, and get the fuck out of here, commie. And you kind of pick on them a little bit, and that's not really the conventional wisdom. But if someone has an adversarial position that is evil, like injustice, fuck that juror. Use them as a foil. Like, call them out, in a respectful way.
Yeah.
It can be kind of funny and humorous at the same time. But you got to call out those people because they exist, and nobody's ever, if they feel that way, they're not going to tell you the truth usually. And most people don't have an opinion. Take people that, they're not out debating liberty and justice for all. They're going out living their lives. Like, no one has a belief system about that that would be against the presumption of innocence. And there's a lot of us that, are very sort of dyed in the wool, pro-liberty, and we have our mind made up. But a lot of people aren't sitting around thinking about what it means.
Yeah, you're just a smidge more. You're like, the evidence is pretty even, but I think just barely the evidence weighs in favor of the plaintiff. Then you'd say plaintiff wins,
right.
They get however much.
And then there's a standard of proof below that, like reasonable suspicion. I'm reasonably suspicious that person committed the crime, so I'm going to give them the minor inconvenience of a stop and have a conversation and determine if I have probable cause. That's lesser. And
it's like, and that's like, it's not even 50% like, probably more likely than not they're doing something. That's just like, there is a serious chance because of the way that they're acting or because of this, that, or the other thing.
Yeah, based on the circumstances are enough to rise to this level for this minor inconvenience.
I'll go ahead and stop them real quick. And
then preponderance of evidence is enough that we think justice is served to pay somebody some money, or to, if we had to have proof beyond a reasonable doubt for a child custody case, you wouldn't be able to get a verdict.
There'd be no custody.
Because I don't know. Like, you seem like a prick, but you're the parents, so you're...
I'm pretty sure that, mom or dad is correct, but, I have a doubt here. There's a pretty compelling thread right here.
Yeah, sorry, kid, you're going to have to live here at the courthouse. So that's not happening, right?
No.
So there's a standard above that, too, and it's clear and convincing evidence. Mm-hmm. It's more than a preponderance of evidence, and it's... The jury instruction for that has always kind of confused me. It seems kind of, when you're clearly convinced, it's clear and convincing.
And I think of it, to me, it seems, just to kind of use like a sports analogy, I think of like if I'm talking with a friend, and if the Texas Longhorns, one of my teams, is about to play the Alabama Crimson Tide, and I say, I think Texas has it this year. I think that we have the better team, we have the better defense, we have the better offense. That's kind of like preponderance of the evidence. Like, I think we're going to win that. But if we're playing like UL Monroe, or maybe I should give a different example of like, like Arkansas, right? And it's like, come on. I'd tell my friend if they said, who do you think is going to win? I'd say, come on. Like, the Longhorns have a clear advantage. I'm pretty freaking confident that the Longhorns are going to beat them.
I'll challenge you a little bit. The consequences matter too.
Yeah.
So if someone asked me, who you think is going to win this? I was like, I'm pretty darn sure, it's going to be the Longhorns. Okay. Would you bet $100 on that? Oh, no, I wouldn't do that, because I need to be convinced beyond a reasonable doubt to risk $100 on a bet, right?
Yeah, definitely. I mean, I'm thinking, and then like the more extreme example would be like Texas is playing, FCS school, Wichita State, and I'm like, okay, like there's almost no way Texas is going to lose. For me, I would think, maybe I'd do a friendly small bet on like a clear and convincing case, like Arkansas versus Texas. Okay, yeah, I'll put.
That's risk
$10.
tolerance. Like so.
Yeah, exactly.
So
I wouldn't put $100, on some of those things.
So the risk in a case that you get it wrong on a child custody case is a loving parent gets the kid, right? Because we know if it's clear and convincing evidence that this parent should not have any involvement in this life, maybe there'd be a termination of parental rights. I mean, you got to do some pretty bad things to have a court rule that you're unfit. They'll give you supervised parenting time at least, right? Mm-hmm. So on a case of clear and convincing evidence, that's still not enough to convict someone of a crime in America. Mm-hmm. Now above that, I always put my hand up there to say there's proof beyond a reasonable doubt. If you're convinced beyond a reasonable doubt that someone committed this crime, ladies and gentlemen, in this case the defendant committed the crime of X, Y, and Z, then you'd find him guilty. There's clear and convincing evidence. That's a lot of evidence. What's your verdict? If you're clearly convinced, but you have reasonable doubt, not guilty. So you make the jurors basically agree that if they think your client did it, if they think it's more likely than not your client did it, in America, that client is
not guilty.
Not guilty.
Sometimes people on, more my side of the political aisle will, they'll say, well, what about all these problems with this country? We have this problem, this problem, this problem. The thing is that the guilt beyond a reasonable doubt, that standard is, it's brilliant, and it's so important for a free society because, well, first of all, unfortunately, even with that standard, you still have innocent people who are convicted, people who are later exonerated with DNA evidence or with, just overwhelming evidence that they were actually innocent. But, imagine if the standard was lower. You'd have innocent people being convicted left and right. For a functioning system, you need to have the defendant have the benefit of the doubt because something about our minds, our minds as people, we for some reason, tend to want to err on the side of convicting otherwise. If the standard was 50-50, if the standard was preponderance of the evidence, imagine, in theory, you'd think that, people will get it wrong, but, generally with the 50-50, people should get it right most of the time.
Yeah, most of the time. I think you get it right, maybe get it right 90% of the time.
But how many lives would you ruin?
Can you imagine a 10% fuck-up rate on trials? That would be so devastating.
Nightmarish, yeah.
The old adage is it's better to have 100 guilty people be let off than one innocent person be put to jail, right? Now, I always find it strange that on the right side of the aisle, I get along best with jurors that are, very conservative, pro-constitutional, pro-Second Amendment, liberty-minded people. And what's the first thing you'd see them on a Facebook post that says, we should execute pedophiles without a trial? It's like, man,
yeah.
They're like, yes, because they are governed by their emotions and they can't think thoughtfully, and that's just a problem with their educational system, that we don't teach people how to think. We teach people how to be factory workers, and that profession is hard to find, nowadays, right?
And there's like a kernel of truth to that. The people who abuse children, that's despicable, evil, wrong. That's the kind of thing that we want to stamp out from this world. But
those people should die, right? Like those people, look.
Or maybe they deserve to die.
They deserve to die, right?
Yeah.
It's hard to. If I'm convinced beyond a reasonable doubt that somebody did something, I don't think I would be if I had any doubt at all, I don't know, I had a hard time.
Like even a smidgen of doubt, I'd be like, oh,
I mean,
yeah.
Can you imagine being falsely accused? I mean, we imagine all the time, because clients all the time are falsely accused of sex crimes, child sex crimes.
Like the most unimaginably horrible things. And I think of that. I think of, almost going to court and being like, look, like these accusations are horrible and disgusting, but our client didn't do it. You know what I mean? Like you should and can and should be disgusted by them, but don't take it out on our client because he legitimately didn't do it. Well, we're not saying that he didn't do some of it. We're not coming up here and saying, well, he only did half of that. We're saying he didn't do it at all. And
but you're walking in with that stigma that
a huge stigma.
Plus, there's this almost a religion that people don't lie about sexual abuse. Like there's people that believe that children and women don't lie about sexual abuse.
And it seems like that would make sense. Yeah, I mean, to the average person would say, how could anybody lie about something like that?
The reason you think that is because you're not a sociopathic, broken person that would lie to get you away. D.A. Trick goes, what motive do they have to lie? Well, they have a tiny little thing to gain. Like, why would they lie about that? Yeah, they're fucking broken. What a sick fucking creature. Imagine the sick weirdo that would be a pedophile. Imagine that same brain on a liar that would harm people for their own gain. Like you would harm a child for your own sexual gratification. Fucking sicko. Like you should be like fucking murdered.
I was going to say, and it's easier. I mean, I could also imagine how somebody could justify falsely accusing somebody of something way more easily than I could imagine how somebody would, hurt a child. Because at least if you're falsely accusing somebody of something, it's not like you see them in prison. It's not like you know what I mean? Like
that's so fucked up.
It's incredibly fucked up. I guess what I'm saying is that like you would think that somebody would be less likely to hurt a child than somebody would be to lie in court like that. You know what I mean? Because you don't have to, you're not confronted by it. Like you can lie to if you're doing something horrible to a child and, in pain and scream, like you can't really lie to yourself and be like, oh yeah, this is totally okay. But maybe
I don't know, numerically, I would say there's numerically way more pedophiles than there are kids that lie about being molested. But on the sad thing, on adult cases, I would say that there's a lot of buyer's remorse liars. Like it's way easier for an adult to lie because they may be just full of hatred because this person was horrible to them. Like for one, like they just got used for sex, for instance, and had no interest, and that's an injustice at the beginning.
If you think about it, kind of building on what you said, if somebody, because to us, I think we would say, why would somebody, just for a small benefit, just for having their partner say, oh, you didn't really cheat on me, why would somebody lie about something so horrible that would harm another person so much? And I think that has to do with somebody being a psychopath or sociopath. If there's any benefit to them and they really don't have any empathy or if they really don't have any understanding of empathy or morals or decency, if they get a benefit, they don't care who they screw over, how badly they screw somebody.
Yeah, but sometimes people aren't psycho and they blurt out like an excuse and then they're stuck in that lie. I mean, it's a horrible thing to do, but maybe they feel really bad about it, but they're stuck. And I think that's the most common false accusation from a kid, where I'm mad, and then they retaliate and they say something if they're actually liars. And then the most common false accusation that doesn't involve as much overt deception by a child is when an aggrieved parent influences the child and blows something that was innocent. Oh, they said this, now I can program them to say it was something worse. And sometimes those parents don't do it intentionally because they're so hypervigilant that they accidentally plant the false accusation by asking these questions, and the kid gets stimulated and is like getting attention, and it just kind of snowballs. So, and we don't need to prove which way it was. If it was the mom intentionally trying to harm someone with a false accusation, which is a grievous thing to do to a child.
Disgusting.
I mean, that's
like horrible. Or it could, as you said, like it could be an accident. Like they were so, worried, they were so passionate about protecting their kids that they accidentally pressured their kid into, saying, "Oh yes, that did happen," because the kid thought that's what they wanted to hear.
Well, it's not like most people don't have training on how to do a interview of a child that you suspect may have been sexually assaulted. You start saying stuff like, instead of like, what happened next, it's like, where did he touch you? And then it's like, oh, he touched me. I gotta have an answer. Because the objection at trial would be, assumes facts not in evidence, right? And you see it all the time in grand jury. You see all the time these DAs saying, give me an example that you've seen.
Oh my God! I mean, I'm obviously not going to say the case name out loud, but the case that we had where the district attorney asked the child, the alleged victim, did your dad do this? And the child said no. And then the DA kept badgering this child. Oh, well, your mommy told me that you said blank, and the kid's like, oh yeah. And of course, we couldn't see the kid, but we could listen to the grand jury recording. But repeatedly, the kid gives answers that directly contradict the DA's story and the story that one of the parents told to the police. I mean, it's really the kind of thing.
It's a form of child abuse. I mean,
and it'd be hard to believe.
Maybe have a mandatory reporting requirement for that DA abusing that child, because I mean that's sick.
Yeah.
The other thing I find interesting,
it should be criminal if it's not,
is that we didn't have access to grand jury recordings in Oregon until the last few years. Just go to trial and not know what they're going to say because the DAs weren't writing down notes. And you'd demand the grand jury notes, and we wouldn't get them. You'd have to show that they were exculpatory. I mean, there was like crazy holes in the data set. Or think of all those injustices, because think how much justice comes out of us hearing the changed story. Like what they said in the police report, the initial interview versus what they said in grand jury. That's profound. And how many cases did people get convicted where the DA never disclosed that there was a contradiction? Oh, well, we would have asked them not to indict if there was a contradiction. Really? Then how come I got all these cases with grand jury testimony contradicting what was said in the interview?
Well, and even today I had a conversation where I had to tell the DA, and he was like, oh, where was that contradictory statement? I said, in one of the police interviews that you sent to us. I was nice about it, and I'm not saying it was the DA's fault, but I remember that one case where we had one of the big breaks that we had was the grand jury testimony for the star witness. I had listened to the police interview right before that, and so many facts had changed, so many gigantic facts that couldn't have changed. I was floored. But without that grand jury hearing,
yeah. But the thing is,
I wouldn't have known.
The DA may not have known about the discrepancies because things happen so fast. They got so many cases. So and if the cops aren't in the room in the grand jury to say, oh wait, that was different. So there's actually kind of a knowledge information gap in the grand jury process due to the speed of getting indictments when someone is in custody, right? Mm-hmm. So I mean, it's a broken system, and it's our job as advocates to alert them of it.
I was going to say, that's why it's so important for people to have a defense lawyer who's going to look into every claim. Because as you said, I mean, there are a lot of prosecutors who are acting in completely good faith who, either they miss something or they don't even have access to the police interview. They go and get the indictment. Just getting an indictment isn't the same thing as convicting somebody, so it's a much lower standard of proof. It's not always malice. Sometimes it's just, accidents happen. Sometimes it's incompetence, sometimes it's a small mistake, sometimes it's just not having information at the same time. But you can imagine how that could and does lead to nightmarish, horrible situations when it's not corrected.
Then we're stuck with the question of, do we let the DA know that there's this gaping hole in their case? So now you got to know the personality of the DA. Are they a truth seeker, or are they a true believer that is just going to say, well, one of the symptoms of child sex abuse is they'll change their story over and over again, or one of the symptoms of having PTSD is your story changes for an adult victim.
Or if they're even worse and they don't care whether somebody's innocent or guilty, they want a conviction for the sake of their career, or because they're.
I always give them the benefit of the doubt, and I think that they're just not critical thinkers, and that their brain just has a problem of playing devil's advocate. That they're very trusting. They got this paradigm.
Especially if they hear one story first. If they only talk
primacy versus recency. So it's confirmation bias, and it takes a deliberate, active mind to model the other side. Some people don't model minds very well. They're just not good at that. Right? They have no theory of mind. Maybe they lack empathy themselves, and imagine the worst sort of client you've ever seen, the worst sort of perpetrator you've ever seen, and assume they go to law school and become a family law lawyer and deal with child custody cases. You think those people are on the right side of the case? Well, we have opposition attorneys all the time in the civil realm, and we clearly think that the case is an utter loser, and then we go annihilate them at trial, and it's like they didn't ever know. And you try to settle it, and you're like, why do you believe this? Are you not a reasonable person? And I feel that same way with with DAs too, like, I don't mispredict trial outcomes. If I say there's 8 times out of 10 we're going to win this case, I've yet to see a case get lost. And if I say, look, this case, have to be a miracle, and if we won those cases, it's because the miracle happened at trial unexpectedly that we foresee as a possibility but not a likelihood. Mm-hmm. So why are those people trying cases and we get a 14-minute not guilty verdict or a 24-minute not guilty verdict? Like, what are we doing wrong that we can't convince these DAs to dismiss the case? Well, sometimes we haven't attempted to convince them because we didn't believe they would if we told them. So we've held back our punches, rope-a-doped it, and then once they get worn out, usually after their opening statement and the fireworks begin and cross, you'd think they'd get it. Like if I got a beating like some of the beatings we put down in cases, I'd be like, Your Honor, may I have a moment? I'd go talk to my cop and be like, I don't think I can good faith can do this case anymore. This person is a fucking liar. And I would move to dismiss the case rather than put this jury through days of watching the whooping, and be honest with them.
Yeah, no, definitely. And I think the jury is also a very nice reality check, because if we said, oh, like this case, 8 out of 10 times we're going to win this, clearly this is in our favor, and then, we have the whole trial and we're like, see, we're clearly going to win, and the jury came back with a 15-minute guilty verdict, then we might have to stop and say, whoa, are we the ones who are delusional here? Are we the ones who are not seeing the other side? So, I feel like it's affirming when you predict that something's going to happen, when you're like, all right, 12 reasonable people are going to see it our way, and then they do. I feel like it's
easy to do. All you have to do is be a reasonable person.
Oh, absolutely, yeah.
Yeah, and there's a lot of unreasonable people that look at the world incorrectly. Like they live in a world that believe exists but does not exist. They don't understand what reasonable people do because they're not a reasonable person. Maybe they lack virtue. Maybe they're very judgmental. Maybe they're just not smart enough to have a theory of mind. I don't think my dog has a theory of mind. Is it because it's an unvirtuous dog? No, it's because my dog is just not smart enough to have a theory of mind. So there's people out there. Like I always think when someone says, "Oh, that person doesn't have any empathy," it's like, really? Maybe they haven't tried. Maybe they lack imagination. Maybe they just need to be encouraged to put themselves in someone else's shoes and say, "Hey, but can you just try to imagine for a moment that you're this other person that you just wronged? How would it feel? Well, I never thought of that before." Yeah. Okay. Well, you probably had shitty parents that didn't teach you that. Mm-hmm. We think it's natural, but man, kids are wild and without empathy. Little toddlers headbutting you in the face and running around being crazy, right?
Speaking from experience.
Yeah, right. You were a toddler once, you remember? But I would say they don't try to challenge the narrative in their own minds because they like being the hero. They like being on the side of righteousness. And when they heard the story at grand jury, they looked these people in the eyes and they saw their pain and they believed them. So they're probably convinced beyond a reasonable doubt that this person is telling the truth. But why? I would never vouch for a stranger. Like for me to be convinced beyond a reasonable doubt someone's telling the truth, I'm going to have to know their family. I'm going to have to know the circumstances. I'm going to have to know all the facts. Like it's almost like they lack a vouching skill. And I think it comes from a lack of community nowadays that it must have been so much easier to date, even 40, 50 years ago when you knew people's parents, you knew where they hung out, you knew their hobbies, you dealt with them at church, or like you had a community. So it's community-based vouching, right? I know this person's good because everybody says they're good.
And usually good people get seen and appreciated, and bad people get found out.
Yeah, they get ostracized, they get a reputation of being a liar. And if you got somebody just cold walking into your grand jury room and they're charming and you're easy manipulated because you either like it, you like being in that position, or you don't ever challenge yourself, that's a recipe for injustice. And that's why jurors, the jury system, is the best mechanism we've ever had in the history of humanity outside of maybe the Second Amendment to control the government. There's really, sure, you can go vote at the ballot box, right? Oh yeah, one vote can make a difference, but one vote in a jury trial can tell the government no. You get a hung jury, right? 2, 3, 4, 5, 6, 12 people in a room can tell the government no and set another man free.
As you've said, the one vote can bring the entire government apparatus to a screeching halt. You know, a single vote can prevent an innocent person from going to prison, sometimes even to prison for the rest of their lives. I mean, you can make a huge difference. And I think you might have even said this, like how often can you tell, you know, the United States government no? How often can you, as an individual, single-handedly affect what happens from the government? I mean, in elections, how often does one vote make a difference? I mean, it does, but not that frequently. What other, I mean, I guess you could,
voting's more like a force multiplier. Like all of us together, we can convey this force to oppose the government.
Yeah.
And in a jury trial, I can be alone and I can be courageous and I can tell the government no. And that's, you know, courage is and we don't have a lot of opportunities to be courageous nowadays, you know, physically courageous. Like maybe you get, you know, fortunate enough that you can go break up a fight, or you can rescue a damsel in distress, or you can put yourself in jeopardy. But we live in very safe environments where discomfort is like the thing we're most concerned about. You don't have the opportunity to go do things physically like that. But with moral courage, the ability to stand up in a minority situation. And I don't mean minority in the situation is that me and all these other people were oppressed and we're all victims, and then you become a majority of a particular community. You know, like your clique in this victimhood group can have power, and you can advance your ways by running a victim narrative. Like that's one way to go about power. But being a man standing alone against your peers and against the government, that's an awesome thing.